and not least our keynote speaker this morning, who is Kristin Sandvik from the University of Oslo, Faculty of Law, and also PRIO, the Peace Research Institute of Norway, and who has written I think you started writing on sort of issues related to this before anyone else in Norway, at least that I know of. And also, it's a particularly, I mean, for me, it's also a personal pleasure to be able to welcome you as keynote speaker, because we've known each other for a long time now. We met in 2005 at Harvard when you were a PhD student at Harvard, and I was there as a guest researcher, a visiting fellow. And you were already formidable at that time, and that has just expanded enormously. So I'm very much looking forward to listening to you today, Kristin. Welcome.
Thank you.
Technology, you know all about that.
Ears. Oh, it's the opposite way from the one in Oslo. No, it's not?
I figured it out finally.
The one in Oslo doesn't have ears like it.
No, but you know in Bergen we have ears.
Are you sure? Like,
No, we do.
presumably this doesn't go on YouTube. This like qualifies as the stupid moments before you get on.
I actually need to say that everything, when you ask, this session will be streamed. So if you ask questions, it will be on the streaming.
So I'll repeat your questions, and if you have questions of clarification, feel free to raise your hand. Malcolm is going to answer some of the technical questions. So I think now we're ready to go. Hi, it's great to be here with you today. So my background is law, legal anthropology. I am not a Luddite, but I am a technological skeptic, I would say. I started out as an activist with Save the Children Norway back in the mid-90s and worked on commercial sexual abuse of children and worked on child pornography on the internet from 1996 and onwards, which I think has kind of shaped my view on a lot of what technology can be used for and digital harm. I have worked on refugee resettlement in Uganda and legal mobilization in Colombia with Julieta Lemetra. Then I had so many kids, so I applied for and got the postdoc on cyber war and international law, which is kind of the second point at which I become very skeptical towards technology. I've been working on humanitarian tech for the last maybe 8-9 years, and then more recently I moved into this domain of legal tech at the Faculty of Law, because we have designed and implemented a lot of new courses around technology. So what I'm going to do today this is basically a primer. I'm going to introduce some basic questions about ethics. It's a methodology approach. I am going to mostly talk about the legal profession, but for me it's clear that this has real implications for us as educators and as researchers. So what I'm going to talk about here today also comes off my experiences in legal tech and robot regulations. Particularly the fact that people look at ethical problems in so many different ways. So the kind of applied ethics that I will be talking about here today is sort of, the morally correct course of action. For the legal profession, that pertains to professional ethics and is codified. In the classes we're teaching, we have a very international crowd, and they have a very, very very diverse views on what ethical problems are. We had one student who left this comment in Canvas, and he said he was from an Asian country, and he said, I'm doing group work with these Norwegians, and every time we have a problem, they want to talk about the state. They talk about the state all the time. And then after a couple of weeks, I realized that they like the state. So if you see the state as some sort of benign paternal figure, Clearly, the way you frame ethics issues will be different than if you see the state as an enemy that needs to be kept at a distance, or as a completely irrelevant actor. In my robot regulations class that I teach with Tobias Mahler, we did lots of group work, but we had particularly one group that made a movie on sex robots. You know, for any academic, this is a point of envy, right? So my students upload this sex robots movie to YouTube. And this is a pretty nerdy film about consumer protection, and with lots of sort of slides of EU regulation. I assume that most people who looked this up didn't actually prepare for that. So 300,000 people have seen this movie. You know, I wish. But it's a lot about ethics. But I also saw that people had very different ideas of what the ethical issues were. And then, for example, apparently the feminist takeaway from this movie, from a very vocal participant from Kenya, she was just her sort of issue with the sex robots industry was the racism. And the racism in the form of this being about white thin bodies, right? I didn't see that coming from a feminist perspective. You know, I mean, for me, the sex robots issue is pretty problematic in itself. But it was very interesting that people would see ethical problems in a very different way than myself. So, this is why I think we now need to globalize this discussion. I've been working on a literature review for a while. It's extremely difficult to find something that is not focused on a US jurisdiction. We see legal tech labs pop up all over the place in Finland, Colombia, South Africa. But generally, so far, most of the sort of scholarly reflection is only US focused. And I think we need to change that. And my pitch today is for a global approach to legal technology ethics. Historically, as we know, I don't know how many of you are lawyers, we are a very protected profession. We're also not a particularly well-loved profession. I think we have to sort of admit that, right? But there's been very little incentive for innovation. We have been sheltered. We have been powerful. And there's been this idea that, you know, the need to regulate this profession tightly would clash with any kind of disruptive innovation. Now that we have a turn to legal technology, the concern is that this will increase the commodification of legal services. But so far, we've been pretty conservative, and there's been a very slow uptake of legal technology. The rise of legal tech. This should, of course, have been a much larger slide. It's a slide of about 5 million legal startups. As Malcolm usually points out, 90% of these will go bankrupt and disappear or be bought by someone else. But a tiny fraction of 10% will survive and will continue to transform the legal market. Most of them originate in the US, and some of them have been around for 2.5 decades by now. So it's not completely new, but it's really growing very quickly. So what are these tools? Smart contracts, blockchain, analytics, machine learning approaches, really things basically to produce new forms of knowledge, to sort and produce information. This has the potential to quite radically change the work of law firms, the type of cases they take on, for example. If you have an analytical tool predicting that you have no chance of winning this case, are you going to take on these kind of cases? It's changing how they do due diligence and discovery. IP technology has the potential to scope massive amount of data at the same time, changes billing. So essentially, structures are shifting. On the other side, there's also legal technology addressing access to justice and so-called citizen legal services. And this is more in the domain of parking bots or how you can file your divorce easily, et cetera, et cetera. But lots and lots of initiatives for ordinary people to use technology to circumvent lawyers and to make legal services cheaper and more accessible. And this is, we should think that this would be a good thing because cost is a structural barrier to access justice. At the same time, the rise of legal tech also means the rise of risk. And this is a risk common to every other societal domain at present. So what I'm talking about is cyber security issues, attacks, social engineering. Somebody's going to lose their chip or their computer or share or not be protected enough. But it's also the rise of risk in the specific relationship that lawyers have with their clients. How do you protect client confidentiality? And also, I think a general risk in terms of kind of unthinking uptake in the regulatory system. So I can only speak for Norway, but we have a very sort of gung-ho tech-focused government at the moment, and they want this to be adopted by as many people as fast as possible, particularly in the public sector. So part of the public sector has been told that they should just use the potential of technology, and the agencies will come back and ask, but these are political questions. You need to solve those political issues, and then we will implement your policy. We cannot carry out policy. We are the implementer. We're not policymakers. So there is a question of whether policy is now being made through practice, which is unfortunate. Last week, we had an interesting example whereby a startup, legal tech, they were specializing in digital wills. They had been able to meet this parliamentarian and basically sell their product to him. So he got their product specifically mentioned in the regulation. And having digital wills, huge rule of law issues. Huge issues with fraud, digital consciousness, digital competence, given sort of the age cohort that are now signing wills. But the fact that this firm was able just to meet with this guy, and suddenly they had regulation. It's pretty incredible in a system like the Norwegian one. So this is, for me, this is a kind of a second type of risk that pertains to the system itself. This is a laundromat. So ethics and technology. We can think about this in many ways when we're going to start scoping ethics. The first one goes to lawyers' professional ethics and the key issues that we know so well about client confidentiality, for example, what the lawyer is going to do and think and say at any given time. These things are fairly regulated in fair detail by bar associations, and people can be disbarred. Then, if we want to think about ethics and technology, there is the question on how we think about technology and politics. So just to scope this pretty broadly, we have what's called the Luddites. These are, historically people who rejected the spinning wheel. But this is kind of the name of a group who will say that any technological change or intervention is bad, it's terrible, we need to go back to pen and paper, which is incidentally also, of course, a technology. Then you have the position further along the scale of the technology skeptics. These people have very often been branded as negative and as spoilers by people who like technology more. I think the technology skeptic position, which is supposed to include some sort of critical thinking, has become much more legitimate. And it's become more easy to have this position now. I'm fighting this perpetual fight against Malcolm because I refuse to be on Facebook. So he's still asking me to be on Facebook. But I have to say, it saves me from a lot of work that happens on Facebook in my private life, because I'm not on Facebook, and no one is actually asking me to be on Facebook anymore, right? So I'm a skeptic. But I think for most of us, we realize that there isn't any reason to trust big tech, and that this idea of digital harm is real. We have digital bodies that can be harmed in a way that is as consequential as the harm to our physical bodies. For example, circulation of nude photos, use of Facebook for incitement to genocide against the Rohingya, etc., right? We realize this is real now, and this trust is good to have. Then we have the positivists. These are people who like technology, They're positive that it can solve some problems. Very often they are determinists too, so they think that technology will work as intended and that there will not be too many unforeseen or distributive consequences that are bad. And then at the far end of the scale, you have what we call the technological utopians. Technological utopians will think that technology is basically the solution for any problem. The technology can solve big structural issues like access to justice or security in a refugee camp, or the whole idea about drones saving people by delivering medicine, for example. So this is a utopian belief in the revolutionary, game-changing potential of technology. And very often, the language will be something like a revolution in blah, 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 or this is going to be a game changer for blah, blah, blah. I've been working for years on drones in humanitarian aid. I think that must have been the most hyped field in the world. This, of course, relates very much to how you frame the problem. And this is extremely important for our students. So what we try to teach them is problems can be framed in many ways. It's not like they're just sitting there by the door, right? It's not like you can take them out for a walk. You frame problems, and then you frame solutions accordingly. This is what Sheila Jasanoff has been working on with science and technology and law. But if you frame a problem, I see now that there's an extra C in politics. If you frame the problem as amenable to technological intervention, somebody will have that solution. And I think for our students, this is extremely important to be aware of. So it also determines who gets to sit at the table, what we discuss at the table, and the issues kept off the table, right? I mean, we all know that the big tech giants spend millions of dollars lobbying not to be regulated, right? So being kept off the regulatory table is also an important strategy. And this brings me to the last point, which is about ethics. I spent the last 10 years doing a lot of ethics work in the humanitarian domain, and now I'm starting to feel sort of unsure about this whole thing. I'll talk a little bit more about that later. But there has been this increasing unease about these tech ethics initiatives. And this is, ranging from drones to wearables to cell phones to artificial intelligence to robots. Is this just a way of avoiding regulation? This is called ethics washing. What are the trade-offs here? What does it mean to have these weird ethical lists, basically? And what we've seen is that these are made by groups that are quite mixed, expert groups of stakeholders, lawyers, activists, and quite often they will come up with platforms or kind of 10-pointers. They're just a mix of international law, domestic technical regulation, what any given person around the table felt was important that day, and some sort of symbolic keywords. So it's basically very impure products that kind of lead nowhere. And also this focus on ethics, very unclear what to do with violations of kind of vague standards, and no sanctions. And then it's, of course, the old question that we ask with respect to legal mobilization all the time. Maybe I should not have gone to court. Maybe I should have spent my resources differently. So maybe I should not have been sitting around this nice table and had expensive coffee with 10 other people from the UN. Maybe I should have gone out and done something else instead of investing in this ethics initiative. So that's the ethics washing issue. And that's also relevant for legal technology. The US context is completely dominant in whatever literature we have here. I already mentioned the literature on risk prediction tools and concerns that cases with high risk will not be litigated. There is a lot of focus on this increasing duty of legal competence to use tech competently and effectively. There is something called the model rules that details this carefully, But simply the fact that to be a responsible practitioner, you have to be able to manage the tech, you have to use the tech, and when you're presenting your evidence, you have to show that you've been using that technology to sort of scope and analyze the evidence properly. There is a duty of care and a due diligence with respect to the protection of client confidentiality, and this idea that you have to take reasonable precautions against intrusions, which means that you have to vet vendors, so you can't buy your legal tech from anyone. You have to make sure that they are not a Trojan horse and the agent of some foreign power or someone who's basically is delivering a faulty product. And you have to provide training for all your colleagues and your employees. We've had a discussion at the Faculty of Law in Oslo whether the law professors should learn to code. And just having that discussion is upsetting and painful for a lot of people who would not like to learn to code. And nobody can force us or them. In law firms, you can actually force people or make that part of people's contract. But basically a training requirement. And also a question of how you organize your services. So law firms, very often they will give trainees, for example, pads to take home, which email accounts you can use, where your office, who's your office neighbor? So in Norway, all the big law firms in Oslo, they are located, next door to each other. I mean, there's significant potential for espionage. I don't think you can have a requirement saying that no other lawyers in like a mile's distance. And also with global connectivity, the question is does it really matter? But I think, we're faced with new questions as to how you keep your business secure. And then there's social media behavior. As for everyone else, increasingly you have to be a responsible adult on Twitter and Instagram and Facebook. But incorporating this into the professional ethics of the legal profession is kind of a gradual process, and again, will also be kind of culturally contextual. But lots and lots of literature on this. When I was teaching the legal tech class on ethics this spring, I couldn't find anything to put on the syllabus that was relevant for my class of international students. So if anyone would like to volunteer to write that paper, I'm a taker. But it's really something that we need to address, because otherwise the debate will, the problems will be the problems identified by these scholars. There will not be problems arising in other types of jurisdictions. I thought I was just going to briefly give you examples of how the ethics of legal tech is relevant as a transnational issue. So I did my PhD on refugee resettlement. I worked as a caseworker for UNHCR on resettlement in Kampala. I went back to do field work. We went through this legal bureaucratic process of selecting refugees. And there's no golden age. These people had no representation, they had no interpreter, there was really no right to sort of assess the quality of the process. This was pretty terrible. This was also at the point of time where UNHCR was trying to roll out a more streamlined digital approach. But nevertheless, this quasi-legal process was modeled on refugee status determination interviews. So resettlement is a durable solution on par with local integration and repatriation. It's not a right in international law, but it does speak to some ideas about justice and due process. If you are going to now start with algorithms screening refugees who will have the success in the domestic labor market, you are shifting resettlement from being an instrument of international protection towards an instrument of economic gain, essentially. So the proposal here from a couple of academics at Stanford is that we will, have this algorithmic platform whereby we can select refugees that will be more sort of able to become breadwinners in the global north. What's fascinating about the language surrounding the people who want to sell this platform is this whole idea that it's free, it's easy to access, and blah, blah, blah. We're going to get back to that. The second issue that I've become very fascinated by is how legal tech can work in transitional justice. So Colombia is, of course, also not a laboratory, but Colombians are actively dealing with this in the post-peace process. Enormous amounts of evidence that need to be organized. Hundreds, tens of thousands of people have been disappeared. How do you actually sort their case files? How do you account for everyone? How do you sort crimes? I read about something fascinating yesterday, which was a legal design challenge aimed to transform the tutelas. And this was actually kind of sort of graphic picture of like these physical bags of paper with tutelas that were being dumped, and how you could sort of have a digital approach to tutelas instead. And then, of course, it's digital forensics, how you collect digital data in a mass atrocity context, particularly with respect to disappearances and killings, and rape, of course, and the need to streamline these. I think these examples are very good because they both pertain to exceptionally vulnerable populations. And the proposals are to subject these populations to fairly unfinished technology. So all this is going to be pretty experimental. We're going to get back to that. But this raises, of course, tons of issues that are not addressed in a global north lawyering context. The third example is this ethics work that I've been doing with drones. I started working on this maybe back in 2011, and then I traveled the journey in a couple of UN meetings in New York and in Bellagio and in Sheffield, actually, and did a lot of work for a couple of years on this. So when we started out, this was the Wild West. So people flogging their drones, they could basically just say anything. I was sitting in this meeting in the UN with a person who was selling his drones, and the drones were also used to identify and kill poachers in Kenya. And this was presented as a humanitarian use of drones because they were saving animals. And it was basically a free-for-all of volunteers. So in the humanitarian domain, with the Haiti earthquake, you had the rise of crisis mappers. Suddenly, these people showed up with drones and insisted on using their drones in emergencies. In the Nepal earthquake, Western drone activists were behaving so badly that they had their drones arrested, and also they were arrested. And that sort of led to a bit of mental reflection in this field, and we started discussing the fact that maybe this is not such a great idea. Maybe there needs to be constraints on how people can use the technology. And then eventually you got UN around the table, you get more kind of serious industry players, and we started talking about rights and duties, and duties of competence to understand an emergency context. But my point here is that the ethics language was a good way of getting problems on the table. It was pretty hard, actually, to get some of these industry stakeholders and UN people to accept that there were problems with these drones. And using the ethics language was helpful for a while. And then once you have that beautiful document, you need to go further and have regulation. But I'm not completely willing to buy this idea that the only thing we were doing were ethics washing. So these are just three examples where much more research and kind of hard work is needed. And it's also really kind of proliferating in global South jurisdictions. This is just, from this year, actually, you see a lot of these. You know, how Africa's courtrooms are embracing legal tech, And again, there has been no, previous golden age where, African courtrooms were perfect. I mean, this has been, it's always been difficult. But I do think that we need to kind of try to figure out what the ethics issues are. These systems are, of course, something some vendor in the West want to sell. They talk about their systems that can reach anywhere globally and provide free instant software upgrades. Nothing is free here. If there's one thing we know is that nothing is free. Nothing that's good is free. You can now log into case files securely from their home offices. No, you can't. So there's this vision of security, which is just basically untenable. They talk about no paper, efficiency, and speed, and they talk about game changers. But I do think that there's lots of room for critical interrogation in domestic jurisdictions at the moment, and this rapid uptake of technology. Which leads me to this question. Are we now entering the third phase of law and development? So, we had the 1970s, optimism, it died, and then we have the 1990s, and some of you are old enough to have done that for most of your career. Like how can we have rule of law, how can we have human rights instruments, how can we get this implemented? And we're still kind of working at that. But the question is if legal tech is becoming some sort of new export. And it's not only an export flowing from, and I know that these concepts are inadequate, the global north to the global south, but also from the global east to the global south, and from the global east to the global north. So it's a bit more complex. But I do think that there's a time to now assess what the past and the lessons learned teach us, and also how they shape our research agenda. And then I want to just emphasize what I've already said, I think. What's special about technology? The digital divide still exists. Parts of the world are still in a digital shadow. Global connectivity isn't quite global yet. So cheap platforms, cheap cell phones proliferate, but the security here is also quite poor, right? Digital literacy remains a challenge. Very little has been invested in the user's digital literacy as the big UN organizations are rolling out their technology, for example. Digital literacy is a challenge all over the place, but particularly when you insist on governing through tech. Data colonialism is real. There's been a bit of criticism of this concept, because if you talk about data colonialism as this exploitation of populations in the global south, that their data, the new oil, is just taken for free, this risks underplaying the real violence of colonialism. And also it risks flattening data activism in the global south. This is not my intention, but I do think that we need to see where the data is flowing, also through these so-called legal tech platforms. And then experimentation in the global south context. A lot of these technologies are not finished. When I worked on drones, I saw how people would take their drones to places where they thought there were no regulation because they couldn't fly in Europe, right? So suddenly you can fly your drone over a densely populated area in Malawi, really? You would never be able to do that in Oslo. Why should you be able to do that in Malawi with no training and almost, just a scant sort of government permission? And I'm concerned about the experimentalism here of using legal tech. So we need to be aware of that, and we need to link these literatures on law and development and critical data studies. With respect to the pointers for research, I think we need to approach this as the ethics of knowledge management and production. There are many, I've only talked about the lawyers here. We have judges, we have legal bureaucrats, we have many other legal providers that will face their own ethical quandaries. Lynette Taylor has talked about this issue of data justice. And maybe that concept needs to be tacked on to how we think about this. And then finally, systematic learning from history, but also from other professional fields. Other professional fields have dealt with this for a long time. We need to try to learn more about what the engineers are doing, what the doctors are doing, what the computer scientists are doing and thinking. A lot of this will not be completely relevant for the legal field, but I think learning is a good thing. This profession, this field is late to the party. So other people have been having this discussion for a while already. So that was my attempt at the broad scoping of legal tech and the argument for globalizing how we think and talk about ethics. Not only to sort of make sure that the American, the US-based perspective isn't dominant, but also so we can have these discussions and do proper research in our own local context. So basically, it's back to the same old point, right? The local context. Thank you.
Thank you so much. This was very informative and enlightening. And we will have a panel discussion where you will be participating, but we thought we would allow some questions that you might have. So Ruth wants to start.
Thank you so much. This is fascinating. It's overwhelming. At the same time, it's same old same, just in new clothes. So there's a bit of... So what is the toolkit that... Because I get asked this question, and I am illiterate. What is the toolkit that someone studying, law school today, willing to be prepared to engage seriously with these challenges, needs to have? What is the kind of training? It's not typically offered in law school, so it's probably going to require, at this moment, people to navigate and look for different ways of training themselves. So what would you recommend for someone who is now in law school and wants to address these questions to, get as a training? So do they need, how much technology knowledge is actually needed? What would...
So I think this answer is going to please you. So we've been having these panels where we've been asking, and again, I have to say, in this field, my experience is so far limited to the Norwegian context, but we've been asking industry, the government, judges, what do we need to teach them? And the first thing they want to have, the ability to produce beautiful PowerPoints.
Okay.
But I don't know how about you guys, but I'm regularly sort of corrected by my 7-year-old who's now been trained in PowerPoints for years, 3 years at school. Kids coming out of school today, they can do PowerPoints, right? So this, I think, is a passing issue. But surprisingly, they would like their students to be aware and interested in technology and not afraid of technology. And of course, they would like them to be competent in navigating the basic platforms, for example, in terms of how you manage case law. But what they want more than anything else are students who can ask critical questions, students who are curious, students who are willing to ask about the downsides of tech and how things work and who gains the advantage, and students who are able to critically conceptualize new things and new problems. Which is nice for us, right? Because we can do this.
So if I send them to do a PhD in philosophy, it's just as good. You know what I mean? It's in the end, it's critical thinking that you want to encourage.
It's critical thinking.
Not more technological knowledge, but really keeping to...
Well, this goes back to the what is new question, right? So whenever you start researching a new technology, at some point you will kind of come back to the old insights. But on the other hand, there is something quite radically new here, right? So the speed, global connectivity. In my field, I've been working on tracking devices for a while, right? So traditionally, if I was, UNHCR, I would hand out non-food items to all of you. That would be things, right? I would give you the buckets. If I give all of you cheap wearables so I can track your health data, what is the product here? Who gets aid? It's clearly you guys giving me aid by all the data flowing back. That's something new. So either you're providing me a gift or it's kind of free/forced labor. So something is new, and and the ability to sort of make that intelligible for the legal profession. So yeah, not the PhD in philosophy necessarily, but yeah, maybe one in social legal studies. And we haven't even gotten to the point of lawfare, by the way. Technology is fascinating with respect to lawfare. And I know that there's a talk afterwards about knowledge production, but one of the things that I'm concerned about, which I didn't discuss here, and I would have if we were looking at the social justice legal tech issue only, when I've been working on refugee organizations in Uganda and IDP organizations in Colombia, it's been for the last 15 years, they've been able to use technology to document their claims. They've been able to use cell phones, witnessing films to show these people were killed, it happens how, these are the threats that came to my cell phone. They've been able to sort of become credible actors who could be competent through tech and be heard, be able to disseminate their message, etc., etc. Juliette and I worked with the Kankwamo. They had put together a big file of everybody who had been disappeared with their pictures that they put online. So the tribe, the community would know that this happened. With deepfakes and fake news and everything, that resource is under severe threat. And I'm concerned that it's no longer going to be part of the toolbox of the human rights community. Or it's only going to be the part of the toolbox of the party with the most resources to really prove that they have verified information. And this is not free. Anyhow, sorry, your question.
Okay, thank you very much for your presentation. It was really beautiful, and there's a lot that I had to learn and try to conceptualize at the back of my mind. I wanted to ask on, because I've been reading around the blockchain a lot, and I read this article that really depressed me on smart contracts and how the blockchain and smart contracts are going to be the end of lawyers. So I wanted to hear from your perspective, do you think that that's going to be the end of lawyers? Because they were saying once we have smart contracts, there won't be need for us to go to law firms. And at the same time with chatbots, if you have a question, you just go online, you use Google, or you go to these tools that you can use, and you basically have self-aid. So I wanted to hear your thoughts on that. And then the other question I had is on data protection. I understand Norway is not part of the European Union, is it?
But we're doing everything they tell us to do. And we pay.
Okay, so I wanted to find out if you have the same data protection laws as the EU. So those are my two questions for now.
So will lawyers be unemployed? I take it you're a lawyer, huh?
Yeah.
Yeah, we're always worried about this. No, I'm sure we're going to find, I mean, as you see, lots of new stuff to fight about. The legal profession, I would not think, is under threat from technology. The financial crisis has meant that there has been sort of a surplus of lawyers, particularly in Anglo-American jurisdictions, and law schools have closed. But it's not due to technology, it's due to structural conditions. I think that for the people around us, clerks, paralegals, I think trainees, technology will change the need for the enormous group of people working around law. And clients have already woken up to the fact that they're paying out of their nose for manual work. But I also think that there are a lot of new professions coming up here. Sort of these, not techno lawyers, but people working on technology that also work in law firms. So I've met now several law firms who say that they do innovation now. I mean, they're no longer pure law firms. They have become legal innovation companies. So I think, you will be happily employed. But it's interesting how things are changing. And I didn't say this, but in the legal tech ethics literature, you have a couple of boogeymen, which are kind of criticized by the ethics people for being either too optimistic about tech and being sort of too irresponsible with respect to the duty of lawyers. But also kind of not realistic with respect to the future employment situation. I wouldn't be so concerned, but I think it's a super interesting field to research. With data protection, yes, Norway is doing everything we can. I think with legal tech, the jurisdictional issues are fascinating. What you do if you deploy the same legal tech across multiple jurisdictions, who owns the data that sits in the cloud, which is a real concern for the transitional justice context, for example. Is Colombian data about disappearances suddenly owned by Microsoft and sitting somewhere else? And who gets to know? Yeah.
Okay, thank you.
So now, okay. Okay. Then it's here, and then in back. Maria first, and then in back.
Thank you for the discussion. Quick question. Basically, we've seen in many governments, I won't name the governments, there's lots of fascination with technology now, especially with the surveillance. And many governments play too much with the surveillance, and they're kind of crossing the human rights under the excuse of development, social security, citizens protection. There are many different excuses. So basically, to the extent that if a person's information is being checked, I mean, the information that you're checking online, which pages you're visiting, can be a reason to be prosecuted or arrested. How far do you think can, according to the human rights still and ethical issues, can we actually let the governments go? I mean, they are stretching those limits, ethical borders. So what is your evaluation about it?
I mean, this is in a way a kind of reply to the same old. Something is new here, right? So technology enables you now to do extreme surveillance. And clearly, you know, kings and emperors have done extreme surveillance on their people before, previously in history. This is nothing historically completely new. I mean, I think, you know, the former East Germany is a pretty horrific example of human-based detailed surveillance of people. It's a difficult question, right? So we're back to kind of the same questions about, you know, democracy, but also culturally how you look at tech. You know, this idea that, you know, why are you afraid if you have nothing to hide? But it's more complicated than that, right? So you have cultural differences in how you think about tech, for example, biometrics. And this also pertains to how you trust your government. But you know, you see that Canada has rejected this quest to remove backdoors, to insert backdoors, and to loosen encryption standards. But more and more governments are loving the possibility of doing surveillance nonstop. And of course, as you say, they motivate this with, you know, we're going to fight child pornography, welfare, fraud, blah, blah, blah. It's difficult. But I also think that we need to do more conceptual work on what's actually going on. So, for example, this whole idea about digital bodies. So what exactly is the problem with the surveillance? You know, what are the real world consequences of the surveillance? Because we are already giving away so much information for free. You know, you're giving away more information about yourself and your kids every day on Instagram than the government is interested and able to collect. You know, where does that personal responsibility and the ethics meet the resistance toward government surveillance? But it's a fantastic field of research, very, very interesting, and much more research needed on non-English language jurisdictions.
So now I have two questions. I have Lisa and then I have Pam in the back. Is there anybody else wants to ask a question? Because then I think we can take those two and then you can reply and then we'll thank you.
Thank you so much for your talk. It was very enlightening. And I wish to ask two questions. The first one is about the topic you were talking about before. I work in this center in FGV, which studies technology and teaching methodologies. And my question is whether you in answer to Ruth's question, you mentioned that it's a critical law structure of thoughts, but I wonder if we are dealing with only new problems and the same way of thinking that we already learn in law schools, for example, or is it necessary to have new abilities to answer the new questions that are coming up? And also the other question was about the lawfare you mentioned. Are we? I am not very literate on technology, but I was wondering if we are right now, once it's a new problem, addressing it like we did 20 years ago when we started addressing lawfare, like saying regulation is the solution for the whole world, and then in 10 years we're going to find out regulation doesn't have any effect. So I wanted, if you could, to expand a little bit of the regulation situation.
No, I was just feeling my sort of like trying to remember what was asked. Can I just answer
Yes,
it?
you can answer.
I'll answer that
Of course
first. So with respect to, so what are we going to teach the law? What tools are we going to use? So, and this is an assumption on my part, but globally, law schools recruit pretty conservative bourgeois people. If they just have a little bit of critical thinking, it's going to make a huge difference. So you can actually nab anyone from the STS department or sociology or philosophy, right? We're not talking about a lot, but the resources are there. Other disciplines have, this is what they do, right? So just trying to teach the lawyers, like one thing that's particularly fascinating about law is this the kind of the magical legalism. Stanley Cohen talks about this, right? Just because something is prohibited, as you just say, it's automatically going to happen. Or the light switch. I have a beautiful law now. I worked really hard on this. It's there. It's shiny. It's like green. It's going to work. We all know this is not going to work because we've been working on the struggles of implementation. But when you couple this sort of professional belief with technological utopianism, it's not great, right? So we have to try to deal with those things in the legal teaching. I don't think it's rocket science, but I think we need to find a way of doing this comprehensively on a pedagogical level. Sorry, your other question was about lawfare. It always goes in rounds, right? And I have colleagues who decided to study law because then they felt they could really do something. I wake up ever so often and think that I should have been a medical doctor, right? Because then I could actually save someone. I think with lawfare, I think we need really to reassess what's going on. And try to see, what vulnerable parties and how the stakes are changing for their abilities to resist, to actually use law as a tool for social change, and to try to understand what's the agenda of the adversary, because that agenda isn't necessarily the same. And I would say, if you want to read more about these things, like Ron Dybert at the Citizen Lab, he's my hero. But they're doing the most fantastic research on surveillance platforms. So just, you follow that lab, the Citizen Lab. It's really amazing.
Wonderful. Now you get the last question, Per.
Yeah, it's maybe more of a comment connected to what you were asking about what students need to learn. I'm a digital immigrant, having lived about half my life with technology, digital technology and digital platforms. And I think our generation, or all immigrants, should maybe reflect on the society they moved into carefully. So I never made jokes about Facebook because I understand that my kids, who are digital natives, live their lives in a different setting than I do and have different backstories and reflections. So I think lawyers who educate themselves today absolutely needs to be intimate with how people live their lives, to be able to think creatively and innovatively on their own profession in this setting. Whether we like it or not, it's here. Whether we participated in it or not, it is billions and billions of reality for billions and billions of people. So, yeah, thank you.
Thank you.
Thank you.
Thank you so much, Kristin. This was amazing. You will get another cup. You've been here before.
Someone stole my cup last year. This
so
is
you actually
great.
need two, probably. So
Last year, good.
But it looks good on with you. Yeah.
Thank you.
Have another cup. And then before we all get some coffee, some chocolate or something else, but I want to take this opportunity because this is, as we know, the last day, and it is appropriate to thank some of the people who are making this possible and facilitating everything. So some of them are leaving, and some are coming. So I will do this twice today, also at the very end. But I would like, so all the people who give, of course, all of you should be thanked for coming, for contributing, for presenting, for lecturing. But there are some people who are doing extremely important work that are not as visible. We have the Law Transform is run to a large extent or almost exclusively on a volunteer basis. And I want to first ask the one who is like the general of the volunteers this year, Uda, is she anywhere around? To come up. So, Uda has been running this ship she's just the most amazing captain on the ship. She's running all of us. And it is amazing. As I was saying, she's absorbing all the things that are falling apart. She's just absorbing it. And then sometimes I have to say yes or no to something, but that's the easy part. So Uda has been sort of trying to manage me for a couple of years now, with limited success. But this, you've really, really, really done in an amazing, amazing way. So thanks a lot. So, and this is, as you know, quite a horizontal space, so everybody gets the same reward, which is that you also get a cup. But you also get some flowers. Because this would have been very, very different without you. So thanks a lot. It's been amazing. Because now Uda finished her law studies, and she started working at the Norwegian School of Economics. They're very lucky. But what Uda has offered or accepted is to now organize our alumni. So she'll now be your general, all of you. But then I also want all the other volunteers who are here now to come on stage. Each and every one. Some people, like Bruna, have come to Bergen just for this purpose, and Alida. Others have been working with us for years. And all have done the most amazing job. Really just super, super, super amazing. So give them all a hand. And, oops, I'm going to give you each a flower. Thank you. And you can go and choose the cup you want. Thank you. Thank you. Oops. Oops. And Marit knows that she will be Oda next year. Lisa, yeah. Thank you. Thank you. Maria, thank you so much. Anna, you'll actually get the bigger flowers, so you won't get it now. Thank you so much. And Anna Husea, she is also one of our generals. She's head of PR, so she's what makes us digitally alive. And she and her team and then what is, I think, one of the other people who are really so, Laura. Laura has coordinated the PhD course, and a lot more. And is sort of Laura is the warm heart of the center on an everyday basis, and really sort of doing so much practical work and so much emotional work. So thank you so much. And then I don't think that Ingvild is here, is she? No, she needs to come later, so then I'll give her a speech later. So, but for now, isn't this a beautiful people? So thanks a lot. And you all need to go and get cups. And then you all need to go and get coffee in your cups afterwards. We'll start again in 10 minutes. Beklager, jeg er helt rå.
You need the one from Syria, right?
Ja, tack. Ja.
Did you get the pictures? Did it work? The pictures?
Did you send me?
Yeah, via Facebook.
Oh, I don't have Messenger, so I've not been able to check the Facebook messages. I'll check later.
Because I thought, how could I send you?
Oh, yeah, you didn't. Yeah, you didn't. Yeah.
You want an email? By email is easier.
Yeah, email I can access on the phone as well.
Okay, but I don't have your email. You want to give me now? Yeah.
Yeah, he's come back from the US, but still, well, he's waiting for sort of his trial, so the media sort of student questions no, it's not that.
What is being used politically for particular rights issues.
Yeah.
Limited as it is, unequality is, I was fascinated by your comment.
Ja, good? No. Da kör vi på lite. Ja.
I have questions sort of touching upon being a pleasure, most of the legal terms that we are seeing are most of them that very common. And I guess this is what I want to
On the live? Oh!
Next time, screen up there.
Yeah. As in, we will start questions.
No, I mean, as in we have problems.
Oh, like that? Yeah. Yes. Yeah. We shouldn't have taken it down to be fair. It's not, she was ready and...
Did she buy the ticket?
I don't know.
Oh, that's trying to like.
Oh, yeah. Should I put it as a...
I thought there was a round table.
Yeah, there's a they have someone sent you this about no, actually, I think they're first doing cover, and then no, I think they're doing presentations. Have the first and then welcome.
Already quite the last one?
Oh, there's something.
That looks cool.
Enjoy your work.
Good day. Yes. Thank you.
Like, do you see like the attendance? Like the one Malcolm did was like the language and all.
I didn't look at the time.
Have you used
Yeah.
It's probably like 50 or 50, 45.
Så har det gått 10 minuter.
Mariana, do you know how many people were here? I forgot to ask.
Let's count them in the second session and add at the same time.
he was released because he had been in prison waiting trial, then the process of trial.
And yeah, here's a question for you, like especially more or less.
That's very
I know you're political scientist, but I thought you very interesting. Yeah. Could you work a bit with the exploitation of labor?
A lot of people want to talk about interesting stuff, but when you're not able to communicate it in a good way, you just can't. But she's done a lot.
Yeah.
I'm interested in the exploitation of labor.
What time you start?
I say I give her 3 more minutes. She said 10 when we had a break.
No, I didn't say that, but yes, it will be that.
I know you well enough.
I'm looking about general perspective first to approach the field.
Yeah.
I didn't work with legal studies before. What would you, the first thing that comes to your mind, like to start with? Like one of the, gurus of, yes, most likely there are some really big scholars in the area.
Forced migrant labor.
Just exploitation of migrants.
Skilled migrants.
Not in China.
Generally.
I know what you meant.
Don't think about China.
I would Google scholar.
Yeah, well, I know.
Who gets 500 citations?
But I guess there's not that much of a discussion lately.
What do you mean by exploitation? Skilled migrant workers? It's a lawyer who works 90 hours a week in a corporate law firm in New York.
Okay,
from
pushing.
Australia, like a couple of my colleagues. Is that exploitation?
Pushing the contract too far. Or discrimination.
Should we make a start? What do you say? We've been 10 minutes.
I didn't count, I don't know.
Yeah. People mean by force. It's a very strong word, force. So,
I mean, I didn't say force, I say pushing the
exploitation is,
yes.
whether it's force is very cheap.
Donkey. I mean,
Only in
these
places like
terms I'm
China,
using
North
now.
Korea would be a good example of.
Yes, the terms I'm using now, they are not really decided yet. It's just shifting. I'm just trying to find the ideal.
What's the problem you're thinking about?
I'm thinking, because, I was talking about my project about discrimination, right? Meaning I was thinking to check discrimination in the recruitment space. Now I understand it will be really hard because, those who are not taken, they want to know.
Who's talking now?
Heather.
Only those people who actually do what they want. So that's why in the working place it's easy to track because then you have this life story in the
Maybe the discrimination in the workplace is skilled professionals. A lot of research on that. Lawyers, doctors in the US, really good data now. It's a whole research.
migrants is the thing, migrants, skilled migrants. So basically, if we're talking about in the US, I don't know, skilled migrants from Mexico coming.
Yeah, no, there is.
Because I don't know anymore. I can't do it, so I don't know.
Yes.
So you can just sort of do that.
Take it up, yeah.
Yeah, no. Yeah.
Okay,
That's perfect. I mean, I'm a sociologist, so that's what I do. So unconscious things is fine for me. It's not like I'm a legal scientist. There are many theories now. You can try with questions to me, whatever. Again, that's the topic. I want basically now to combine it with legal studies, just a big picture of it.
And here, there is one here, but it's like a...
Sorry, do you have a staple by any chance? Like a
staple, yeah.
Yeah.
I'm just thinking, I'm treating bases the same or not the same as done before. Skin foreigners. That's what I'm talking about.
Yeah.
So I need to
Okay, everybody, we are going to continue now with a panel after Kristin's keynote. And I'm going to introduce Heather, who's working at DV. I'm not sure what is the English name. The Digitization Directorate, which is, tasked with digitizing Norway. And I suppose it's my natural voice.
Every time. Okay. Here comes God. But she's just started a PhD at the University of Oslo as part of our digital lawyer project, which I lead with Kristin. Looking both at education of lawyers on digital literacy, some digital competence, but also researching in new areas, whether it's legal technology, whether it's robots, or the introduction of algorithms into the public sector. So Heather's got a grant to work with us. Although very strategic as a PhD fellow, she's managed to maximise the distance from her supervisor, me, by living, 1,000 kilometres away. So she's going to be very independent in her work. But she's going to talk about her initial research and surveys on what's happening in the public sector in Norway. And Heather, by background, is a PPE, which is, if I recall correctly. Well, you're from social science, so yeah. And law, but she's also done a master's in law, so she's very interdisciplinary in how she views the world. Hello.
Thank you. Can you hear me? Yes. Yeah, I can actually hear myself well. Okay. So as Malcolm says, I'm going to talk about algorithmic governments in the public sector. Just to explain a little bit more, as Malcolm said, I'm with the Norway's Digitization Directorate. And I'm going to do my PhD, which I actually officially haven't started yet. Yeah, but I think it's too late to save myself. I think I'm in there now. And together with Lisa, who unfortunately couldn't be here today, she works in she's a PhD in NTNU, and she's in the Institute of Sociology and Political Science. So what I'm first going to do is talk a little bit about myself and contextualise what this is all about, and then go into what we're actually doing within the Norwegian public sector around algorithmic governance. Just a little bit of history about me. When I started in DeFi 9 years ago, I did open data. So I led the open data movement, shall we say, from the Norwegian public sector perspective, so Data Norway NO and that kind of thing. And in the last few years, I've become increasingly interested in the actual use of data, how it's used within the public sector, and how public sector data can and will and should be used. I'm become increasingly aware of this. There is now this critical juncture where we have to think about how AI is being deployed and how to make sure that it promotes, not hinders, democratic values such as freedom, equality and transparency. And nowhere is that more important in our work in the public sector. And I was very much in agreement with a comment that came here from the audience. We can't stop this. We're not going to stop this. So how do we balance this? How do we make this for societal benefit and get the best out of it, while at the same time avoiding the pitfalls? So Kristin was mentioning that there is a gung-ho technology government. And Norway is not unique here. It's very much around the world, very huge in Europe, and almost a competition as to which government can be most digitized and which can be digitally transformed. So in 2017, the OECD came with their Digital Government Review of Norway, where they said, amongst other things, that the data-driven government for Norway is an untapped potential, and that we don't have a sense of urgency around it, and really encouraged Norway to have a sense of urgency around being data-driven and having a data-driven government. There's a statement, historically Norway has a statement which is med olje skal landet bygges, so that means that with oil we're going to build a country. And then the digitalization conference this year was with data, we're going to build a country. That was the public sector conference. This is the digitization strategy, which was announced in June of this year, and it's about increasing sharing of data and value creation. So there's a real focus now on how we're going to increase sharing of data, both within and outside the public sector, and how we're going to create value from this, and a lot of economic value as well, and service delivery. And then over here on the left is that Norway is going to have a national strategy for artificial intelligence. It's not solely about public sector, but the public sector is part of that. So we may ask ourselves, you know, why think particularly about the public sector? This is a huge private sector issue as well. Kristin was in, and we've got Google, we've got Facebook, we've got big tech. Why is public sector a huge issue? And why should we look at this in some way, in an isolated way, and do critical reflection here? Because we were also in the discussion you were in as well about surveillance, is the governance is so much more complex in the public sector. We have huge governmental decisions, huge consequences. Will children be taken away from parents? Should they stay with their parents? We had some extreme weather now recently where there was landslides and a road was closed, and the police opened the road, and unfortunately a man was taken by the landslide and died. So and we've got huge health issues. We're talking life and death situations. When do we have the machine involved? When do we have the humans involved? How do we stand over these decisions? We also are hugely accountable for for every decision we make. We have to be able to back it up. We have to be able to show how to do this. And Kristin was in on it, you know, that there's also huge trust in the public sector. As she called it, what was it? A benign paternal figure is the way that we are seen by very many of members of society. And we want to preserve that trust, preserving that trust. And with machines, with artificial intelligence, how are we going to do that? How are we going to manage to preserve that trust, make sure we don't go too far? We need to critically reflect how we are implementing this, and we need to make sure that there is reflection within the public sector on this. So that's what I hope to spend the next 4 years of my life researching and influencing. So our research, and when I'm talking about Lisa and Mai's research, we want to start by mapping and understanding what's actually happening here. Let's find out what's happening before let's diagnose the problem and then look for remedies to it. So we've actually started. This week we conducted 8 interviews with, these are all large public sector bodies, digitally advanced as well. I have to point out, and I'll come back to that. So it was Statsbygg, which is the state building. They do all the state buildings. Innovation Norway, the customs, so that's toll. Lånekassen, which is the Norwegian State Educational Fund, the Cancer Registry, the Norwegian Tax Authority, the Institute for Water Research, and then the Public Services Pension Fund. We are looking at the responses to the public consultation on the artificial intelligence strategy. Not all of them, of course, are coming from the public sector, but some are, and then we're taking the private sector as well. And then we've had 33 responses to a survey, which we circulated. We're hoping for more. We will have more, but we're just starting and getting going and trying to get a picture of what's going on here. So I'm just going to first look at the issues that need to be considered or should be considered in the public sector context for artificial intelligence. This actually comes from Joanna Redden from the Data Justice Lab in the UK. She did a study of Canada and the implementation of artificial intelligence in the public sector in Canada. And she identified these issues, and she looked at discourse and practice in Canada and what's been talked about. What's the awareness about? Are these issues actually being brought up within the public sector? Now, she did this largely through freedom of information requests. In Norway, we are very lucky because we have access. Lisa and I have access to the public sector, a lot of access. We can ask and get deeper in as well, so we're not just dependent on freedom of information. So we've used this as inspiration for our work. What she found, and I'll come back to what our preliminary findings are here in Norway, is that everyone talks about infrastructure, right? This is the easy thing. This is the technical infrastructure. And we've so many technology people within the public sector as well, and this can often be led by technologists rather than our social scientists, let's say, for example. Access to data is a huge issue. It's often seen as like the silver bullet. If we've access to all this data, think of all these seamless services and this fantastic future we could have. Privacy and security, huge issue. Information security is seen as a huge issue and will continue to be in GDPR as well. Obviously, data quality, because obviously if we're providing services, we have to have the right quality. And then skills and competence, actual analytic skills in the public sector. What few were talking about, at least in the Canadian situation, again, I'll come back to Norway, is discrimination, ethics and bias data. You know, we have huge potential here to do the wrong thing, to do ethically wrong things and to discriminate. And there are examples from the US in particular on bad experiences there. Citizen data literacy involvement. Are we able to have this conversation? Is the conversation actually being had with citizens? Are they understanding the implications here? Legislation policy frameworks, is this being thought about? Are they suitable? Are they for the implementation? And then ensuring human influence. Are we only trusting the machine? Is the machine going to make all these decisions, or is the human going to be brought in, and how to do that? Replacement of workers, brought it up in the law area, is also this being talked about within the public sector in terms of jobs. What no one, she found, was talking about is the public-private partnership and how this may limit democratic systems. How are there decisions being made? Public-private partnerships are a huge issue now. They're hugely important to get cooperation with the private sector to keep things going, co-creation, that kind of thing. And then the question is, is there a chance here that the private sector is going to start making too many decisions on behalf of the public sector, too many that should be being made by the public sector but are made by private sector because they have the access to data and their potential to deliver these systems. And then how these information systems may change the way citizens and societies are understood and governed going forward. So these are all the kind of issues, the broader issues that have been identified. We also added a few into our survey. So, for example, organisational culture as a specific area. Now, Redden talks about it, but she doesn't actually have it as a specific issue. So I'm sorry now, most of this in Norwegian, but we asked what the biggest challenges were regarding the adoption of AI in their organisations. And the absolute biggest one was organisational culture, both in the sense that there's too much pressure to get artificial intelligence and to use it and to be the first out, and also organisational culture, that there's too much resistance from this and it's too hard to get people over to new ways of technology. Privacy security is the second one. The third one, it was in Norway at least, was legal and regulatory, both the hinders there with the current legal system, but also the changes that need to be made. Access to data quality, the infrastructure, the actual technical infrastructure to be the platforms from which to build these services, but also to access the data. The financing, analytical competence, so the actual competence to actually analyse the data and to use the data to create these services. How to actually use it, so the whole issue of artificial intelligence has been brought up, but how to actually use this within the public sector is an issue. Citizens' insecurity, ethics, low, but I'll come back a little bit to that. Pressure from leadership to do this, and then the fear for bemanning, replacement of workers, thank you. So you see that the organisational culture is absolutely, and our interviews support this as well. So there was also a big spread throughout the public sector into where the issues were, so we decided we wanted to go in deeper into interviews with them to go deeper into the results. So our preliminary findings are that there actually are very few machine learning models are in production within the public sector. Mostly are in the planning phase. And this isn't just because they can't, which gives me hope. It's also because they really want to think through this. Very many in the public really want to think through what the implications are. How do we make sure we do this in the best possible way? The other positive is that we're not, as we'd say in Ireland, closing the stable doors after the horse has bolted here. There is a chance here. We're following this. It's not going as quickly as we originally envisaged, which is a good thing. The complexity of artificial intelligence seems to be understood by the street-level bureaucrats in these digitally advanced organisations. There was a very clear awareness of the issues here, what to do, what not to do, and a very sense of responsibility, that we have such a responsibility in the decisions that we make and the work that we do. There's definitely a major understanding there. There's a big variation in how data is actually being used. So some want to use it for reporting, some want to use it for policy making, some want to use it to create, this is the big one, the seamless services, right? So that the citizen doesn't have to think which organisation it goes to, but just gets services pushed to them when and where they need them at exactly the right time. And then case working tools. Now this is interesting as well, because this could have different governance issues depending on how the data is going to be used and depending on how artificial intelligence is going to be used. So I'm looking forward to digging into that more. This is highly prioritised by leadership, for good and bad, because leadership, of course, they want to be the best as well, right? So they want things to happen. They want the examples. They want the case studies. They want the stories to go out with. Okay, so this is an issue, and then at the same time trying to balance that with the reality of this. There's a clear understanding that this is a multidisciplinary problem. We can't just have lawyers in one room and technologists in another room and subject matter experts in the other room. This has to be multidisciplinary if we're going to spot the problems before they arrive, and also to make this a reality. Area of concern, this is largely dependent on individuals too. This is dependent on the fact that these organisations have managed to get in these highly competent individuals who are very aware of the situation, the complexity here. What gives us hope as well is that in-house competence is preferred. Now this is partly because this is the thing to do now with technology, is to insource in-house, right? That's partly because of that. But it's also, and came up very many times in our interviews as well, it's also because they want to be responsible for decisions that are made. They want to make sure that these decisions have been made by people who understand and who will stand over these, and we don't just get consultants in and then they leave, right? So what's very clear already just after this week and the survey process, we have to get out to those beyond the digitally advanced organisations. We have to find out what's happening there. Is that just going to be done by consultants coming in and leaving without understanding what the actual role of the organisation might be, for example? And we have to start talking to politicians. We have to see what's this big social discussion that needs to take place. So just to do a kind of very preliminary mapping for where, based on our findings so far, on where we think Norway is at and the Norwegian public sector in terms of discourse and practices and what the awareness and concerns are. Absolutely everyone's talking about exactly the same things as Canada. Now, this is a much bigger, it's a big issue. It's the nature of our public service as well, I think, was probably causing that. Now, I'm torn on this one over here. I'm not really sure where it's going to end up. We need to re-listen to our interviews and go through the data a bit more and find out. But this wasn't a huge issue, and often my impression is that very often when we brought it up, it seemed to be along with privacy and security, rather than, because there can be bias in data, even if it doesn't need to be personal data to have bias in it, right? So we need to go back and see that more, and dig deeper into that. Ensuring human influence came up, wasn't a huge issue. Replacement of workers, not a huge, didn't come up too often either. We're making this yellow here, saying that few are talking about this because of the in-house building up in-house staff. Now, the other thing that I didn't say there was these are digitally advanced, large public sector organisations. They're able to attract staff, yeah. And they also, and what very many said was, we can't match financially with salaries, but we can match with this samfunnsoppdrag. What's that? Society, yeah. Contributing to society, right? We're contributing to make society better. So that's that. I'm less concerned about that, at least within this group. Now, I think it would be very interesting to talk to smart cities, for example. They're working a lot with the private sector. What's happening there? How much data has been shared there, and how many decisions? So I'd love to talk to them, and we have access there. So watch this space. The two areas where there was nothing about, now, the citizen data literacy involvement, there's a lot about the user in the centre. But whether we're at whether we're actually managing to involve them in the discussion as to what society wants, whether we're actually managing to, we're coming up with services, or the public sector is coming up with services, but perhaps not having that discussion beforehand to say, we are considering this service. The cost of that is this data needs to be shared, it will be done in this particular way. Is that okay? That phase, that pre-phase probably isn't happening to the best way. Now there's a lot of discussion, as I say, on the user side about designing the service and how it should be and how they would like it or whatever, but not that pre-work. And this about how changing information systems may change the way citizens and societies are understood and governed is not actually coming up. Now, whether that would come up at the organisational level, this is something that we probably need to bring up much more at the political level and make sure our politicians are capable of taking this discussion. So that's just a very basic very first step into my PhD and what we're coming up with so far. Thank you.
Hello? Okay. So, Malcolm Langford, I don't think I should need to introduce myself. You've heard enough of me this week, but it's just 15 minutes more, so hang on. So I work in a rather schizophrenic way on law and technology issues. So on one hand, I'm involved in a number of legal technology projects. For example, trying to develop a robo-lawyer to help people complain to the European Court of Human Rights. We have a project now with the court administration, trying to help them be more effective in how they allocate judges and calculate case time. Using data-driven approaches, we're involving students in those projects. On the other hand, it's some normative work with Kristin around ethics or social justice issues from legal technology. But then there's a socio-legal dimension. How do we bring social science perspectives into this? And this is what I'm going to talk about today. And it comes perfectly after Heather's presentation, because do you remember the red box at the bottom? It's how citizens understand and respond to algorithmic governments. And this is what this project is about. So it's a project that Kristin Sandvik and Kjersti Lohne from University of Oslo and I have been working on for the last year, mostly around coffee, but we managed to actually get a draft paper together for Law and Society Association in June. And it's precisely on this. So I'm going to ask you a question to think about, and we're going to come back to it later. If a 15-year-old girl shares a naked picture of herself with a 15-year-old boy, is it a violation of the law? 15-year-old girl shares a naked picture of herself with a 15-year-old boy, is it a violation of the law? Just think about that question, and you'll understand why when we come back to it. So the basic idea here is that our lives increasingly are ruled by technology. It shapes very much our emotions today, the way we work every day, and it has a number of effects in our lives, not just trying to get people's attention, okay? Do you mind if I strap your phone to my forehead so I can pretend you're looking at me when I talk? But it has three transformations, we argue, in the area of law. The first is technology is displacing law. And it's a very famous statement from Winner in 1977. He says, technology in a true sense is legislation, as it shapes the basic pattern and content of human activity. So imagine in 1997, if some American from a company in like San Francisco knocked at your door and said, could I please have all your photo albums and all your holiday pictures? I'd like to store them back in my company. Would you open the door to him? Would you go to your lounge room and take out all your photo albums and say, sure, that's great. But now what we do every single day of our lives is precisely that. So 20 years ago, we would have said that's a violation of my privacy. There's problems of transparency here. But suddenly we're doing it. Now, some people would say, it's the same position, okay? Google in San Francisco is still a stranger to me, and I wouldn't trust them now as I wouldn't trust them in 1997. Others would say, well, social media is part of our lives. We see the benefits of social media, of sharing information, of connecting with people, whether it's leading revolutions in the Arab Spring, or whether it's building networks, building businesses, doing this conference that we've had this week. And I've done a different trade-off. And for me, privacy is not as important as these social benefits. But what is the difference between 1997 and 2019? Well, it's just the technology. But it's reshaped the way we think about privacy law profoundly, because we hand over half our data to corporations. So it displaces law. As I said, technology shapes the basic pattern and content of human activity. And good examples of this also come from self-driving cars, okay? You're suddenly faced with an accident situation. Do you swerve to the left where there's two elderly persons, or do you swerve to the right where there's a younger child? Okay, they're your two options, okay? That's a moral decision that you have to make. And there's a whole abundance of philosophy theories, going back to it, that might help you make that decision or not. Now, if we give the decision to the self-driving car, how do we program that car? And that just may be inbuilt standards, So does the self-driving car have a utilitarian approach? Does it have a human rights approach as to how it navigates that decision? Secondly, it confounds law. It disrupts our whole notions of what is public and private, and I've given some of the examples already about Google. But even more so is like national jurisdiction. So we have someone here doing a PhD on this. If you want to investigate, for example, hate crime, or if you want to get evidence for the recent terrorist attack in Norway, which I would argue is a right-wing, was a Christian terrorist, in fact, well, a lot of the relevant data is sitting in the US. Can prosecutors then get access to all that Facebook and 8chan data? Well, then they have to negotiate with the American authorities, and they struggle with this. And the American authorities then struggle with Facebook and so forth. So suddenly so much of our law is no longer Norwegian law, it's basically US law. But then partly regulated through Brussels. So my basic understanding is technology is created in Silicon Valley, abused in Beijing, and regulated in Brussels. I mean, that's the pattern that we're increasingly seeing. Finally, technology inflects law. It becomes embedded in lots of legal processes. And you've already heard about this today. Someone mentioned smart contracts in the Q&A. Some would actually say they're dumb contracts, okay? Because what smart contracts are very good is basically doing very simple transactions, okay? Purchase 10,000 iPhones from China, $1 million goes through. Everything's very detailed, technically spec up. When the money comes through, the goods are released. You don't have to have humans involved in the execution of these contracts. But many contracts are way too complex, actually, for the blockchain technology behind smart contracts. Maybe they'll get smarter over time, but still we now have all this automatic execution of contracts going on. Heather's been talking about also automated decision making, okay? So when you apply for family reunification now in Norway, it's a computer who decides at first instance, okay? It's actually not based on machine learning, it's based on expert design, where they program in all the law. And then if you don't get that, then you can appeal to a human being. Interesting, it's called Ada, which is named after the first ever computer scientist from the end of the 17th century, who was actually a woman. So anyway, we have automated decision-making. Kristin's also talked about legal technology in different ways in which we embed technology in dispute resolution, enforcement mechanisms such as predictive policing that we're seeing all around the world. So, as Kristin importantly mentioned, there is the hype train. Okay, lots of things are hyped up. Heather obviously has to be diplomatic with her research, but there's been a lot of big hype projects, such as customs, for example, bringing in this American data where they can basically track you at the border to see if you're a risk, and including going into your Facebook account and so forth. And it was just like, whoa, that didn't actually get adopted. Many things will disappear over time, but some things will remain. Some legal technology will come into place. Less in Europe, quite a lot in America, and extensively in China. So it will vary across the world. So what Kristin, Kirsty and I want to propose is a research agenda to study how citizens respond to this. What we've called techno-legal consciousness. It builds firstly on an existing literature that goes back to the 1970s on legal consciousness, and anyone who goes to Law and Society will know about this. It's a study of the understandings and meanings of law circulating in social relations, okay? How we actually understand a law. So there's law as written on the books, okay? There's law as lawyers interpret it, okay? In arguments and judgments, and then there is the law in our heads, in our social relations. And those three things may be the same, or they may be completely different. And it's been categorized or problematized in three different ways. Sometimes our legal consciousness makes us subservient before the law. Okay, we're impressed by all the symbols of law, judges in robes, the seeming neutrality of law, or being able to go to court and save the world, okay, lawfare on some ways. And therefore we have a legal consciousness which makes us very subservient, and someone like Susan Silby argues that it has this hegemonic force that makes us very subservient, to the law. Another approach is with the law, where you might actually be more tactical in exploiting the law for your own purposes, exploiting all those grey zones, like a good contract lawyer would do in litigation. But someone mentioned, Kristin mentioned tutela procedures. I mean, everyone is using tutela, in Colombia for all sorts of things today. And it can also be against the law, okay? And that's more the sort of legal activism, trying to challenge legal homogeny with law. There can be a critical approach to this, unmasking power, as Susan Silby would argue. Others are just more interested in understanding, okay? What are our cultural understandings of law? Others interested in comparison. And others wanting to close the gap. Okay, how do we close the gap between that legal consciousness amongst citizens and actually law in practice, and how can we improve social relations? On the other hand, there's a tradition not as strong in technological consciousness that we've been increasingly reviewing. And Miller's work in 1978 is really groundbreaking. So technology creates its own forms of consciousness, and we view it as truer or more transparent or more objective than others. And that's, I think, is really fascinating that law and technology have these similar attributes, okay, objectivity, neutrality, and benevolent power. And technology, it's important to note, is not just the glass, okay? So that's a form of technology, but a technological system is pouring water into the glass, okay, which requires movement, picking up two different objects here, and a result. That's a technological system. And we spent just a million years getting to that point, and you can understand why things are going so quickly now. But she would also argue that technological system includes all the people behind it, all the engineers, the IT people, the financiers, and so forth. And the systems we have today, like Facebook and Google and so forth, are good examples of those deeper systems. And it has a particular power. This goes a bit back to my methods lecture as well. So technological developments often begin as means, okay? But they soon become ends in the end, okay? So I need a car to drive me from Bergen to Oslo, but suddenly the car becomes this amazing thing. It becomes my life, my culture, and if you put a toll on it, a bomb hanger on it, then I'm going to start a political party, because this is about, So we start, and like Facebook or whatever it is starts to increasingly dominate our lives. We often have alienation as we move from needing to manipulate the external world to manipulating our tools, okay? So I kind of have control over this whole process, right? But when I go on to Facebook and I like something, that has consequences that I don't have control over. So when I like your post on Facebook, it feeds into an algorithm which will show me more of your posts in the future, and the reverse if I don't like. So there's all these, that's just one of multiple consequences. It'll affect whether Facebook will show shampoo advertisements to me or dress advertisements. It also leads to linear incremental causal forms of thought, because it has a particular quantitative but also an a-theoretical logic, which we don't see necessarily in quantitative methods. Everything's about prediction and a natural development of things, and not necessarily necessary and sufficient conditions, which we might need for more critical thinking. And utopianism, as Kristin mentioned, that we can solve all of mankind's problems with technology. So the field that we want to try and launch in a way of studies, and we need empirical studies, is the idea of techno-legal consciousness. And this is a nice statement from technology which we could apply to the field we want to develop. We need vocabularies to make sense of the untidy, uneven processes through which the production of science and technology becomes entangled with social norms and hierarchy. This combination of law and technology, and how we end up in what we call techno-legal consciousness. And this is nothing new under the sun. Perhaps one of the most important technological revolutions was the printing press. And I could talk more about why, but it transformed the way we relate in the same way that social media transformed. We had singular text that could be distributed over a country easily and efficiently, and it changed cultures dramatically. I mean, just the novel. Okay, there's one book which argues that human rights were invented with the novel by Lynn Hunt, as it helped us empathise with people who were further than us, maids, prisoners, torture victims. It has a profound cultural effect. So how do we define techno-legal consciousness? The assumptions that structure, inform, enable, constrain and routinise the thoughts and actions of citizens in techno-legal spheres and spaces. And form a kind of techno-legality which we could talk about in this displacement, confoundment and inflection of law. And just to give one example of something that combines everything, okay? And that's regulation of hate speech, okay? So we have a displacement issue because we have new forms of hate speech which are happening in different spheres, like in the US, but they're happening by Norwegians. They're difficult to regulate. It confounds legal systems because how do we track all of these forums and all of this hate speech? But then we have the inflection as well. What is the solution to hate speech? Well, it's private companies that will develop the machine learning algorithm which will track hate speech, which will close down different accounts. So when the recent terrorist attacked in Norway, his Facebook account was automatically closed down that day. They have a system in place. But it means we give over regulation to a private actor working with the public sector and actually implementing law. So that whole process now of regulating hate speech is techno-legal, and there's a question then of how we react to it. So the questions that we could ask in such a research agenda: how do people understand their social security rights when decisions are automated? How do people negotiate contractual disputes when they're faced with a plethora of jurisdictions and dispute resolution forums? How do you decide whether to post a picture of your child on Facebook? Okay, is it okay to post pictures of your children on Facebook? I mean, there's a whole debate in Norway amongst bloggers, which Kristins are being followed. And what are the social norms and the actual rules around that? How do people accept the inbuilt standards in technologies developed by companies? Okay. How many people have read a contract for an application on their iPhone? Actually read the contract. So when you agree to a Facebook app, the Schisse app, like getting the app for just taking the trams and buses around here. Did anyone read the regulations? No. We just accept it, and that's a new form of techno-legal consciousness, actually, where we actually agree not to have actual consciousness. We basically delegate it to Silicon Valley or some Norwegian company. And how do Bitcoin and big blockchain challenges used to create new forms of technology. And then I'm going to finish with a concrete example, which we've got an empirical study starting on this semester. And that goes back to where I started. The 15-year-old girl who shares a naked picture of herself with the 15-year-old boy. So sexting is widespread. American teenagers between 18 and 24 were surveyed. 40% have shared a naked picture. For Europeans, it's 30%. But even when you get up into higher age brackets, okay, up into the 60s, 70s, you're still getting figures of 10, 20%. So it's become a new practice. And it's also a subject of pressure. Come on, just one pink. I think you're sexy. I don't know. I don't want to show you my picture. I still won't show it to anyone, ever, I promise. This is the picture that's shared. Now, this is the exception, okay? Because another survey of teenage girls, 500 girls, 2/3 said that they'd been pressured to actually provide pictures, and many actually had. But the question here is, okay, what is our consciousness around here? Because formally, it's child pornography. That's the existing law. That's what we've spent 20, 30 years on in terms of working on child sexual abuse and getting these legal standards in place. But then we get a whole technological revolution after all these very strong laws and police units in which, as you said earlier, children spend their lives on social media. That's where it happens. The sharing of a naked picture is not viewed by teenagers as child pornography. Now, physically, if you show yourself naked to someone, it doesn't have this pornographic dimension. But suddenly, when it's done through technology, it's captured by the law. Yeah. Mm.
They had to go through a long series of focus groups to try to determine what these kids felt were naked.
Mm.
And it wasn't necessarily, what we would think was naked or culturally what's naked in an Indian culture. And naked was particularly correlating with whether you were sexy or not in a photo.
Mm.
But there's an interesting thing about looking good or bad. The nakedness was much more obvious if you were looking bad.
And that's a really important point, is that basic ideas are culturally constructed. I grew up in the island of Bougainville in Papua New Guinea, and what the part of the body that you were not to show was the ankle, okay? So all women walked around topless with a very long skirt, and the point of the skirt was to cover the ankles, and that's how nakedness is constructed. So technology here is actually transforming what we mean by nakedness. But what are young people concerned about? Well, they're concerned about consent, okay? It's actually the sending of the pictures without consent or being pressured. That's the issue for them. But the law is not necessarily so developed, or the police are not so much focused on that. And so we've got a student this semester who will actually be doing empirical work, interviewing Norwegians, but also Americans, and younger and older persons to get their understanding of this new field of techno-legality. Thank you. I'm actually... Yes, as I thought, yeah. Which is a risk.
On.
If you try to talk.
Yeah?
Yeah, go on. And then
Premise, yeah.
So this session runs until 11:30.
Yeah.
Where do I sit?
There is about 30 minutes.
Fantastic.
No, 20 minutes.
20 minutes.
Yeah.
Very good.
Okay. Too much information and everything is so exciting. And so I'll start with Kristin on the issue on lawfare and technology. I wanted to find out from you, like from the Norwegian perspective, how are the courts interpreting especially social media and information communication technologies when it comes to probably serving of legal documents or process? Because currently in South Africa, you are now allowed to serve, say, summons via Facebook, but a few years back you couldn't. So the judges realized that so many people are trying to run away from the law or trying to avoid having court process served on them. But if they are online, then we can serve court process to them either on WhatsApp or on Facebook. So I wanted to find out from you, is it the same thing happening in Norway, in the Norwegian courts, or it's a bit different?
You know, I'm happily ignorant about Norwegian law. But generally, you know, it seems like we have dragged our feet a lot more in terms of digitizing the legal system. So I don't think anyone would ever think that we should do this via Facebook or WhatsApp in Norway. I mean, it would be unthinkable today, I think, that this would happen. But it's also because the system itself has enough resources to digitize, right? There isn't that much lawfare, but I do think it's just tremendously interesting as an example of a domestic national system using a private provider as a vehicle for implementing legal orders. So I don't know if last week some of you saw this YouTube, or actually 2 days ago. So there was a couple of the wife, and they had a platform on YouTube where they were talking about life as a gay woman and sort of communicating with audiences, and they were censored for language, but they were also demonetized. And the whole larger question of the business models of our social life, of our public life being given to the algorithmic regulations of these providers. So these people were, censored because of family concerns and investors and ultimately their fear of being regulated for supporting hate speech and extremism. But, what could Facebook do to the South African legal system if they decided that the language was not proper, for example? I mean, it's just a very scary way of censoring through algorithms.
Yeah, that's true.
I'll say one thing of that, because I was a lawyer in 1997 where we went from paper to email and we went to PDFs. And it was an amazing transformation within a month, because you wouldn't believe how much effort there is to file a document in a court case. Getting there, printing it out, wrapping it up in a folder, putting the red ribbon around it. The legal assistant then goes up to the court, it's and then it goes to suddenly you save like 2 hours of work just emailing it. And things went much more fast, more effective, but it's a private actor who then provides the email service. And I think it's an interesting point in the global south when the global north and the global east, as you say, are providing services which are way beyond what governments can provide. So I think it's even more.
Interesting. Namita?
Yeah. Here you are. Thank you so much. This was so interesting and such a lot of knowledge. I have a couple of questions actually. So, yesterday I said that, in countries like India, the development discourse always trumps the rights discourse. And then I want to add something to that, which is that within the development discourse, now the overarching discourse is the technology discourse. So digitization is the solution to everything. And so I work on land primarily, and we find that, there's this huge program on digitization of land records. And that is believed to sort of get rid of so India has a lot of land conflict, a lot of land litigation, and the land litigation has the maximum amount of pendency. And so the idea is that, digitizing will fix it. And this also sort of comes from like, having more transparent property records from De Soto's work and so on. But then digitizing is so they're just going ahead and digitizing like paper records, but the paper records themselves are not updated. Many states have not had land surveys for 30, 40, 50 years. Some have never had it at all, like in the Northeast. And so what you're, putting into the technology is basically garbage in is garbage out, is what's happening. And so in that sense, I think like the questions that you've raised, and there's not even enough talk about who's going to maintain these servers and so on, but also the fact that, now the person who's maintaining the technology, like earlier, in order to like change something on the paper record, there was a proper process. Now you could just change something digitally and change somebody's name on the record, and thereby, take away people's rights very, very easily. So there are all these rights concerns that are coming in, which nobody is even talking about. And I think that is something we really need to seriously engage with in these contexts. Right, and so I guess, and the second thing I want to talk about is the fact that, so I have a friend who works at Facebook, and he was visiting India a few months before the Indian elections, which were held in May, and he told me the BJP was going to win. And at that point of time, the polls were not predicting the kind of victory that was coming, but he said just by Facebook ads, and I was not seeing any of them, because Facebook, I guess, decides who gets to see what. But the kind of knowledge and that they had about what was happening in India, and nobody in India had that kind of knowledge, and it was really shocking. I was like, no, that doesn't make any sense. That's not what we are hearing on the ground. But he said, no, just wait. Yeah. So I think I guess these are more like comments about how serious this issue is and how difficult it is, and it would be really useful to develop knowledge to understand them. Thank you.
Say something brief about the land issue, right? So there's something called the hype cycle, which looks at the uptake of technologies and what happens in a 5-year. And last year, blockchain, for the last 2 years. Yeah. Blockchain has been the answer to the land rights problem, and then we have this discussion of garbage in, garbage out. And now apparently, at least for the ICT for development hype cycle, apparently blockchain has finished. But I think it's more complicated than that, right? There are good things with blockchain. Clearly, it's not perfect. But I think it's a good example of you find a technical solution, it turns out not to be perfect, and then you keep tinkering with it. Yeah.
Yeah. I think Rachel, okay, I have a question about how to do research on consciousness, as Malcolm was telling us, because when you were speaking, in my mind it came that it's really hard to have the resources and to how do we assess people's consciousness if it's not like big research conducted by government?
So, in terms of, say, the existing legal consciousness field, I mean, there's been studies on everything. Let's give you a list. Abortion, begging, cockfighting, fat acceptance, housing occupation, indigeneity, medicine, migration, ombudsman, sexuality, sex work, sharing economy, etc. So the last 30 years, we've gone and studied how people understand culturally the law. It's been very dominated by anthropology and the methods of anthropology. So very much, and partly sociology. So interviews with people, some field observation, some use of surveys. And so what we don't have yet actually in the paper is a sort of methodological discussion, which we need to write, because actually studying techno-legal consciousness would also suggest a whole range of methods, including technological methods like quantitative text analysis, because there's so much data now on when, and it's actually this sort of data that's been used to develop legal technology. So we worked this, some of our students worked this year with the DNB Bank in Norway, which developed a legal chatbot for their staff. And they went through the emails of all their staff that they always send to lawyers in-house. So what are the typical questions and what are the typical answers? So they used all that data to then develop the chatbot. So I think it's a real interesting methodological question about to what extent can large N and computational methods help us understand techno-legal consciousness, which then raises kind of the interesting thing if you're also being critical at the same time to the very methods you use to then and also it's
But I think, like, you know, your quote from Jasanoff, we're also in a time period we're just conceptualizing and trying to understand will form a large part of that research on techno-legal consciousness. So, I mean, in the break, Rachel mentioned, you know, what happens when you train your students properly in data security and cybersecurity consciousness and responsibility, and the provider is bought by someone else, and you can no longer trust the provider. That's a paper I'm just begging you to write, actually, based on your experience, because it happens across the field. Another really fascinating topic, for example, is we talked about the changing parameters of motherhood and whether you own your child's digital body. Something else is the monetized childhood of the child's digital body online. So your child will earn 1 million kroner and show it, you know, eating ketchup on YouTube. You know, where do child labor laws come in? Right? Like, you know, how can you actually use your child for commercial gain online? You know, what's the legal regulation? So we're in a period of just conceptualizing and identifying. So we have methodological challenges, but also we just need to try to sort of desperately grasp at what's actually going on here.
Okay, and Rachel.
Yeah, following on from that, it's a fascinating discussion, but I was kind of thinking methodologically how you're going to get at techno-legal consciousness. And let me give an example from kind of the people that I work with and my students, right? On the question of security and insecurity. Mexico is a country where basically trust in government is very low. Government just bought Pegasus spyware from the Israelis and has been using it against journalists. We train most of our students with Article 19 on digital security. I'm sure we're not as good as we could be, but we're trying, right? And most of them are human rights activists, so they're kind of aware of that insecurity, the possible insecurity. And yet they live their lives and their activism on social media in a way that, you know, freaks me out. I mean, just on a kind of basic, everyday, do you put so much information up there that you can get kidnapped? I mean, like anyone in Mexico has that knowledge of what you should and shouldn't be putting up there. But yet they seem to hold these two things, and maybe we all do, right? In ways that we know what we should do to keep safe digitally, and then, you know, it just takes one time that you don't put the VPN on, and that's it. So I wonder if there's how you're thinking about tracking the kind of contradictory dimensions of techno-legal consciousness, and if you're going to do it, maybe one way of doing it is doing it with activists or students and kind of actually tracking what they do or getting them to track digitally what they do. If you could do it in some collaborative way that was actually going to help increase people's security, but I'm not sure there is. I mean, I kind of come to the conclusion that the only way to be really secure is that you just do not put some things ever in digital format. Ever, right? Because once it's in digital format, ultimately you can't control it. I don't think.
So I think this is really important. It shows the limits actually of interviews and surveys, because we say things that we don't necessarily do, and that's actually why the social media companies and others are so powerful, because they follow our behaviour. And that follows the whole behavioural turn in economics and psychology. And I think that it would be interesting methodologically to say, and there might be some sort of working with, could be activists or students or other people over time, and them sharing their data with us, which would have to go through that, or looking at other online sort of troves of data which actually shows these patterns. But I think also, you're also raising a theoretical point, is actually trying to capture the dissonance and the contradictions. So we're almost back to the ontological and epistemological gulfs that we were talking about yesterday. You know, how do we walk around having two completely different normative value sets at the same time? I'm freaked about Facebook, but I put everything on Facebook. So.
I think that this also pertains, maybe this is also a study of cultural change, right? So I think we are about 5 years past sharing is caring. And I think we're now going to go through a phase of, one thing is, you're actually going to be a really horrible mom if you have your open Instagram account with your naked kids on. I think one thing is that it's changing relationships, but also responsibilizing people for putting others at risk. And I think that's going to be painful, and I think, we're going to have example after example, but the platforms are going to change, right? So, we talked about, the fact that people are digital natives, quote unquote. Facebook isn't going to be around forever, but maybe we're going to miss Facebook. The day WeChat has taken over everything. Who knows, right? But we're also in this phase where that sort of Northern American global dominance is coming to an end. But I think this is about culture as well.
And I also think that maybe one way of going around it is through digital literacy. So some people, they just post stuff on Facebook. They are not aware of the consequences, or they share information on different social media platforms without knowing the consequences. So once we start having that digital literacy and engagement to share with people, teach people the consequences that come with being on social media or not reading the terms. Recently, we had that Face app. Many people downloaded the app, no one read the terms, and somehow, a company was downloading personal data, but people were just excited about having that photo and what you look like 10 years later. So I think it also boils down to digital literacy, to teach each other, like, okay, these are the consequences that come with you being on social media or using this technology.
Yes.
It's something they're doing in Finland. The entire population has to take a course in artificial intelligence, the potential consequences of it. Wow. So that's coming through as one of the proposals for the artificial intelligence strategy for Norway, that perhaps that should be done in Norway as well, that everyone should have this basic level of understanding of artificial intelligence to try and involve in the debate. So
maybe you can also answer Rachel's question, because you're studying, in some ways, techno-legal consciousness in 10 different agencies with different methods. So you're actually ahead in some ways. So what's just your reflection, given Rachel's, and also the question up the back?
Yeah, I think it would be fun to try and explore. Could we bring in the public sector into that? Just when you were talking there about, because you didn't really have any dimensions of the public sector, but could we bring in the thing there, and how to have that consciousness also within the public sector and within the citizen, and how we relate to the citizen as well. So it could be a lot of fun. So we should talk. Yeah.
Okay. But just one added element, and I'm not going to talk forever now, but there is this question of relationships and biodata, for example. So if my brother-in-law takes that DNA test and sells off the entire gene pool of that part of the family, my kids are potentially screwed for insurance. Right? And that's a hard negotiation to have, right? I would like you not to do this because of something in the future that we don't know the consequences of. And for those of you working in global health, this idea of more data and this interface between digital devices and therapeutic delivery mechanisms. So, the vagina ring, which will give me your biodata. It will tell me where you are. It will tell me how often you have sex. I can actually control your fertility from a distance. And I can even withhold food if you're not applying that fertility restriction properly, right? I mean, so that sort of link between digital devices and medical applications, I think, is also super relative and relevant for the context we have here today.
Okay. So that we'll discuss next. Okay. For Heather, artificial intelligence. I know you're just starting on your project, but I would like for you probably to share with the audience on the implications of artificial intelligence with discrimination, because from my readings, there is a lot of racial discrimination and gender discrimination through the use of AI. So what are your thoughts, preliminary thoughts at the moment on that?
Yeah, I think, and actually, I didn't show them, but I actually had 2 examples of that, because Amazon is very good. That's the one with discrimination against women.
Yes.
Because they used historical data, right? If you use historical data from
You're turn on.
If you use historical data from Amazon, who have they employed? It's a recruitment. Who have they employed? They've employed mainly white males. So that was what it was giving back. Now, luckily, they stopped that. But what's scary about that is they had the best data scientists in the world. That's who they're attracting. And still, they made that mistake, and they almost had it out in production before it was done. The other one then, the racial discrimination in the US, that's the predictive policing one.
Yes.
Where, a girl who'd taken a scooter, she was considered to be more risk than a guy, Vernon was his name, who had a much longer history of theft and crime, and it's how I think the big reflection that I have and the discussion that I'm missing within the public sector is that it's things about personal data. Right, and we're missing that actually it's the non-personal data. Our characteristics are still in the data, even if we take out personal data, if we take out race, if we take out gender, if we take out all that, there's still, because what's happened in that predictive policing one, they looked at the socio-economic environment. They didn't look at the individual. They looked at what was happening in that socio-economic environment which the people are living in. So this becomes then a self-fulfilling prophecy. Right, because you're keeping these stereotypes, you're embedding these stereotypes, and these stereotypes are embedded in the data. And how can we avoid that in the public sector? How can we avoid to sustaining these stereotypes and making sure that that's not taken in? So I hope that will be a big part of what I get to work on. So I'm not saying that personal data is not a huge issue, because it actually is, but how do we actually move the debate to our characteristics which are in the data and the stereotypes which are in the data? How do we get there, and how do we get the public sector working there and identifying this before it actually happens? Like with Amazon, it was almost there. They were almost recruiting staff based on this highly discriminatory system. Okay. So I hope that we can move that discussion. And yeah.
Anyone from the audience with a question on AI?
You have to look at the Time's up.
Time's up.
So you can close the session now.
Okay, thank you very much. It was a very interesting and productive session. Thank you.
Well chaired, very good.